Is out-of-state property probate necessary? If you have ever wondered what happens to property when someone passes away, especially if that property is located in a different state, you are not alone. Many people find themselves in this situation, and it can be quite confusing. Let's break it down. When a person dies owning real estate in a state different from where they lived, probate is usually necessary. This process is known as ancillary probate. Each state has its own laws and procedures for handling probate, so the property must be probated in the state where it is located. Probate is the legal process that validates a will and manages the deceased person's estate. Real property, which includes land and buildings, is subject to probate in the state where it is located. On the other hand, personal property, like bank accounts or vehicles, is typically probated in the state where the person lived, regardless of where those items are physically located. Ancillary probate serves as a secondary probate process. It is required to transfer the title of real estate that is located outside the deceased person's home state. The personal representative appointed in the primary probate must petition the court in the state where the property is located to open ancillary probate. This involves submitting certified copies of the primary probate documents and complying with local laws. Each state has its own unique rules, forms, timelines, and tax implications for probate. Some states may have expedited processes for smaller estates, while others may requiring more extensive procedures. Ancillary probate ensures that the property is transferred according to the laws of the state where it is located. If you are planning your estate and own real estate in multiple states, it is wise to consider how this can affect your heirs. Using trusts or joint ownership arrangements may help avoid the need for ancillary probate. Elder law attorneys often recommend consolidating property or creating estate plans that minimize the need for multiple probate proceedings. Executors and personal representatives should be aware of the requirements for ancillary probate to manage out-of-state assets effectively. Consulting with attorneys licensed in both the state where the deceased lived and the state where the property is located can be necessary to navigate this process smoothly. In summary, out-of-state property probate is generally necessary to legally transfer real estate located outside the decedent's state of residence. Ancillary probate is the method used to achieve this, ensuring compliance with local laws. Proper estate planning can help reduce the complexity and costs associated with ancillary probate.